All rise. The Supreme Court of Guam is now in session. The Honorable Chief Justice Robert J. Burke presiding.
Good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number SPR23-001 in the matter of the Guam Bar Association certification of results from special election and amendments to bylaws. Appearing is petitioner attorney Jordan Powling. Appearing for respondents, Guam Bar Association Board of Governors, is attorney Vincent Camacho. The panel consists of Chief Justice Robert J. Torrald, Associate Justice F. Philip Carbolino, and Associate Justice Catherine A. Merriman. Attorney Powling reserves 10 minutes for rebuttal.
You may proceed, Mr. Pauline. There's no one else, no other petitioners going to be arguing today except for yourself, right?
No, I'm the only one that'll be arguing today. I did put out a call to inform an email call to inform everybody and ask for feedback or interest. And I had some responses, but nobody had indicated a desire to argue this morning.
All right, you may proceed.
Your Honor, and may it please the court, the petitioners in this case seek review of a vote held by the Guam Bar Association purporting to adopt several proposals that are either plainly inconsistent with the rules governing the Guam Bar Association or are otherwise improvident measures. Additionally, the proper procedure in the election wasn't followed, and there were some procedural defects. The proposals in this case, though, have some fundamental errors. One, they create a third unauthorized and inferior class of membership, which has been dubbed temporary active members. Two, they impose arbitrary qualifications on holding office within the Guam Bar Association Board of Governors. And third, they remove safeguards of independent oversight from GBA financials and election results. So
Mr. Pauling, I want to go back. I'm in terms of the process and your introductory remarks. Because I may have missed it in the briefs, but first of all, Rule 7, Section 1 allows the GBA, the board, to adopt bylaws, and there are rules prescribed. I thought that that process was followed in terms of notice, opportunity, and the majority of votes that were garnered for these amendments. So what process was violated what rule was violated in when these amendments were adopted?
So one of the things is, if you look at Rule 7, and now just to be clear, there are two separate sets of documents that govern the Guam Bar Association functions. There are the Guam Bar Association rules, which are adopted by this court. And then there are the Guam Bar Association bylaws, which were originally adopted by this court, but are actually rules of the Guam Bar Association.
I follow that.
So I just want to make that clear as I talk about the difference between the two. If we look at Rule 7, which discusses the bylaws, it actually doesn't empower the Board of Governors to propose the bylaws. It actually empowers the entire association, and the presentment of these is done by a petition of 25 members of the Guam Bar Association.
Well, that's one group that can do that, but why couldn't the officers themselves propose amendments which the rule allows for the GBA to adopt, modify, and put to the vote of the membership the adoption of proposed bylaws?
Yes, they're certainly put to the vote of the membership, but again, it is a membership function, not a Board of Governors function. And
I don't think they're taking that position. That they're the ones who can propose and just adopt the bylaws, but they submit it to the members to vote on.
But I think this is really at the heart of it, is the proposal function in Section 1 of Rule 7 is actually committed to a petition of 25 members. It does not have, as far as my review of it, does not have a functional portion that allows for the Board of Governors.
Where does it say that it's exclusive, that it's only the 25 petitioners or members that can petition a change and propose an adoption to the bylaws.
It doesn't say that it's exclusive, but the problem is that's the only mechanism that's contemplated in the rules. And so it actually doesn't give the Board of Governors the power to propose these. I can't find anywhere in the rules or bylaws.
And just how practical is that, Mr. Paloon? If you're going to rely that it will take 25 to make any proposal to keep up with the changing times in reference to the operation of the Guam Bar Association, even if you are to interpret it that way, how practical is that to govern an association of such with a larger membership?
And I agree that there may be more practical ways of doing that, but doing that should be done through amending the rules of this court, not ignoring the plain text of the rules. So if we want a more expedient way of doing it, I think that it's certainly a valid concern, but we should do that by actually adopting a rule.
So is this the first time that the Guam Bar has amended its bylaws?
As far as I am aware, yes. Since their adoption, I believe this is the first time, and at least, and rather it's the first time, it's certainly the first time in my years in Guam, and I believe from what I had found in the historically in some of the statements, it's the first time in many years that there's even been an attempt to.
So when these bylaws were originated, it was originated by the court and not the association, the Guam Bar Association.
Yes, and so the rules as they exist today, both the rules and the bylaws are were originally adopted by this court, and I don't think that they've ever been amended by the Board of Governors through or through the association through an election.
I don't know, so I'll take your word for it.
Yeah, and I can't find evidence that they have been. I can't tell you with 100% certainty, but I cannot find evidence that they have been. But I also think that whether that's an efficient or inefficient way of doing it, we need to follow the rules. But I also think that the procedural things here just kind of underscore what are really the substantive problems with the bylaws that were voted on in this particular case. And one of those things is that they are plainly inconsistent with the rules that are actually adopted by this court, in the sense that the rules specify that there are two classes of membership, active and inactive. And it says there shall be two classes of membership, and then defines how we actually determine who is active and inactive.
But isn't temporary active under the active category?
It could be under the active category, and it could just be a simple administrative recognition like we have in the Guam rules of admission to the bar. But if you actually look at how the structure of the rules are set up, temporary active members are then only actually explicitly granted one right, and that is to count towards a quorum. They actually then
that to me, that's a separate issue. I mean, once you recognize that temporary active, whether or not violates the two group description in the articles, how you treat them, I think, is a different issue as to whether or not there's the power to create them or whether that's inconsistent with the articles.
And I think the power to create that third classification, though, would rest with this court, not with the Guam Bar Association. And I think that's where one of the main differences is, where the Guam Bar Association has held an election that then creates this third category and then creates them as an inferior class of membership by not extending them to the same rights. And we have some of the examples from other jurisdictions that have been included in some of the briefing. For example, up in the CNMI, they do talk about temporary active and active members within their rules, but every time they refer to one, they refer to the other. So they say active and temporary active members, and all of the rights, whether it's voting, holding office within the bar association or other things, accrue to all temporary active and active members. Here, what we've done, though, is carved them out and then not extended the franchise to them, actually removed the franchise from this category of people. So I'm not sure that the actual labeling of the temporary active members for administrative purposes is necessarily the true sin here. It's the labeling them like that, labeling them as that category and then removing the franchise from them, removing the right to vote, removing the right to participate. Because at the end of the day, they're still going to want to, the temporary active members are still going to be expected to pay their dues, but then they're not going to be allowed to vote in the Bar Association.
Hypothetically speaking, can the Guam Bar Board of Governors create the temporary active membership and recognize them as having the entitlements as an active member? But for purposes of classification, because they mostly fall under the government attorney category.
So
the question is, can the board create a temporary active category and prescribe entitlements similar to active members? Whether it makes sense to do that or not, it's just not the issue.
When it comes to the power, I still think no. I still think the power to define those categories exists under the rules, not the bylaws. And so that power to define the categories actually belongs with this court, and it doesn't belong.
That position is a result of your interpretation that a temporary active member is not under the active membership category.
I think that's under, if you look at the new proposed bylaws that were voted on, that's not an interpretation. That is what it does. It creates two categories, temporary active and active. And then with one exception, when it comes to counting a quorum, it only refers to giving those rights to active members. And so, maybe one of the ways to, to do this is if there is going to be a recognized category of temporary active members, would be to amend the rules and to allow all of the rights and franchise to extend to them. I think that's really the crux of this. It's there are issues with labeling people and over labeling things in the marginalization context, but the real trouble is that the vote and the rights of membership don't extend to this classification of members under the proposed bylaws.
Let's address the residency issue. What would be the standard that we should examine the residency requirement that's set forth? You seem to suggest it's a strict scrutiny?
I don't necessarily. So I think that there is some strict scrutiny that extends to classifications like this that impinge upon a fundamental right, such as a fundamental right to travel, which then comes with holding office and other things. There are at certain levels of government and policy making levels, such as a governor or a justice of a Supreme Court or even a judge of a trial court, the Supreme Court has recognized some that strict scrutiny will be met at those upper echelons of governmental power for imposing some of the durational and residency requirements. However, when it comes to the Guam Bar Association Board of Governors, it's supposed to be a democratic self-governing entity, and it does two things. One, excludes temporary active members and from holding those offices, and then second, imposes durational and residency requirements that impinge upon somebody's right to engage in their profession and to travel freely. The right to travel is not something about just, it's not a right of ingress and egress. There is part of that in there, but it is part of that right too is to travel freely within the
but you don't cite any authority to support that a membership in a business entity or organization such as the Guam Bar Association triggers a strict scrutiny review. It doesn't involve a suspect class. It doesn't involve a fundamental right.
Yeah, it does involve the fundamental.
And it pertains to a business regulation in reference to the how the association operates.
So if you look at page 10 of the reply brief specifically, this is one of the examples that comes to mind. I cite the case of Goldfarb versus Virginia State Bar Association, which was out of the United States Supreme Court, that actually strikes down a minimum fee schedule from the Bar Association. And so it actually, the bar associations have been included within that class of regulations that might violate, whether it's an antitrust act or a fundamental right to travel, have been included in that fundamental category. Additionally, the Supreme Court, considering similar antitrust concerns in North Carolina Board of Dentistry, found that a professional organization like the regulating organization like the dentists suffers from the same concerns. And so the Supreme Court has actually addressed this issue, and professional groups and professional membership and regulating organizations are subject to these types of strict scrutiny and antitrust analyses. So, I'm not sure it's fair to say I haven't cited anything on that front, because the Supreme Court's actually addressed at least antitrust concerns with respect to.
How does that apply to the classification here of members of the Guam Bar Association in terms of the business that they conduct here in Guam? I mean, we don't have an antitrust issue here.
The problem is you might not have an antitrust issue now. You may have an antitrust issue should these bylaws go into effect, because what happens then is it excludes a certain category of individuals from participation in the governing association of that enterprise, creating monopolistic concerns. That's actually what happened in the North Carolina Board of Dentistry case, dental examiners case, is what they were doing is it was all dentists on the board, and they were starting to exclude certain people that they didn't like. And the Supreme Court said, yes, this is an antitrust issue.
Yeah, but I don't see it that way here. I see it as a business regulation issue, and whether or not there's a rational basis for it.
And that's the exact argument that was advanced by the North Carolina Board of Dental Examiners and was rejected by the United States Supreme Court. It's not. The other thing, though, too, is if it is a regulation of, even if we set aside the antitrust concerns, they are there, they are valid, but even if we set those aside and look at it as a business regulation, what is happening is I don't think that there is a rational basis to exclude a politically unpopular group of members solely because they're admitted under a different rule.
Well, counsels for the respondents can articulate there are reasons for the how it contributes to the governance of the bar, but in reference to just satisfying the rational basis test, if that's what applies here, articulating a reasoning that it supports and contributes to a more efficient governance, that in itself seems to support a rational basis for such a rule.
But that reason has never actually been articulated in this case. There are the platitudes related to better and more efficient administration, but how does extending the right to vote and participate in the Guam Bar Association actually burden the Bar Association? One of the things that was cited to in the briefs and other things is the need to follow the resignation of temporary active members. That's actually not the Bar Association's function anymore, because that actually belongs with this court, and there are rules and procedures adopted for resigning even your temporary active membership, as well as your active membership. But there are rules for this court to actually follow the temporary active members throughout the course of this thing. And additionally, when it comes to the durational and residency requirements, the law encourages democratic and political participation. Somebody without ties to the community is unlikely to actually be elected.
So Mr. Paloon, my thinking, the debate in my mind does not have to do in reference to where I sit as to whether or not this is the best way to operate. My thinking is, number one, do they have the power? Number two is, does it violate the rules in reference to the proposed amendments? I don't think I myself would want to micromanage how the Guam Bar Association operates its governance. That's not the partnership that I think we embarked on when the Guam Bar Association was created. Clearly, if it conflicts with the rules, then I think it's a role that I should play as to whether or not that is in violation of the process that has been established. But whether or not it makes sense. It's the right thing to do. Shouldn't that be left to the membership, the majority, as to how they should operate themselves?
At the end of the day, though, there are certain fundamental participatory rights that if even me, Mr. Pawloon, was the only one that was being excluded by this, no political majority should be able to take away certain participatory rights.
Then why don't you get your 25 petitioners to propose a change and bring this to the membership at this annual meeting?
And I guess that begs the question, why weren't 25 members approached to even to propose this in the first place? I think that fundamentally, though, this does come back to that it violates the rules. And at the end of the day, this court still has plenary authority over the Guam Bar Association. And as the California Supreme Court does and has done numerous times, has the right to even just disagree de novo, basically, on the policy that was.
I don't challenge that we have the power to intervene and determine whether or not this is the right way to operate. The question is, should we?
I think at a time when we're having trouble recruiting attorneys to Guam, having a shortage, I think that's actually one of the times in which we need to do it.
So why do we even need a Guam Bar Association? Why doesn't the court just operate the regulation of the lawyers and how they should operate here in our territory?
In many ways they do. Historically, both, and Guam actually follows somewhat of the several years behind, but the historical delegation and separation of powers between the court and the Bar Association. It previously, for both of them, the Guam Bar Association and the California Bar Association handled a lot of the attorney discipline and ethics issues. All of those things, through other rule changes and everything, have been pretty much created within an institution of the Supreme Court of the respective jurisdiction. What the Guam Bar Association primarily does now is helps with some of those ethics issues, but also, more importantly, deals with promoting CLEs, having committees for lawyers' assistance programs. The list of committees that was proposed under these rules was actually a really fantastic thing. It'd be one of them is the lawyer's assistance program. Nobody's challenging the need for a lawyer's assistance program. I think that that's actually one of the best things that's been proposed in a while. But at the same time, it excludes from participation and governance of those things from the very lawyers that would then end up participating in them. And so,
can we jump to the certification issue now?
Yes.
Because you raised the issue that the vote tallies weren't presented to the court. But I didn't see an explicit requirement that the certification of the election include the specific vote tallies. Are you suggesting that they voted on the amendments as a whole and not each amendment individually?
No, I think they voted on each amendment individually. I think that was clear from the ballot and other things. The problem is, when petitioning, all I got was a notice that says these passed. So I never saw the certification or the tallies or anything else until they were filed as an exhibit in this case. Those are the types of things that we don't certify an election outcome by just saying this side got more votes. We typically do it when we're actually taking a ballot by certifying the number of votes for each thing. And yes, they've submitted it after the fact, but those aren't actually included in the certification, nor were they made available to the membership at the time of petitioning.
And then you make, I guess, a to-do about the typo in the certification or in the proposed article that says it's going to be determined by electronic ballot by the board of, and then didn't include the word governors in that.
Yes, and and the complete text rule applies, and this court has even recognized the complete text rule. However, and all of these procedural challenges are of valid concern, but I think what they really do is highlight the real problem here of disenfranchising a category of membership and making the Guam Bar Association, subject to less oversight, whether it is in trying to make election results final or removing the independent financial statements from the CPA, or just creating this other class of membership. We really cannot expect lawyers to move here, build their lives here, and eventually become a part of the community if what they are going to arrive to is the age-old taxation without representation mentality. We will take your bar association dues, but you cannot participate in full in the organization. The only thing you do is count towards the establishment of a quorum. The storm clouds that have been brewing for a long time related to legal services, this isn't going to solve all of it, but it's going to be a big step by allowing people to be included in the entire franchise. So the petitioners ask that you set aside, I guess it's I'll be specific here. It's overrule proposal 1, 3, 6, 7, and 12 because they don't have the effect of actually promoting confidence in the Guam Bar Association or participation of its membership. What it does is it creates a marginalized class of members that shouldn't be recognized. And more fundamentally, for the people that are currently operating under that rule, it doesn't just create a new barrier to entry, it actually takes their rights away. So I'd like to reserve the remainder of my time.
Justice Merriman has a question.
I'd like to go back to the residency issue.
Yes.
One of my colleagues suggests the Guam Bar Association is a private sort of entity. But looking at the president of the Guam Bar Association, she has duties under law as president of the Guam Bar Association. Doesn't that make her a public official? She's on the board of law examiners, for example, and she has other public duties.
Yes, and I think those residency requirements, though, would be better addressed by careful rules crafted by this court. So
for her, just her,
just the president.
What is the difference between requiring her be a resident and have 5 years experience as a public official?
So, I don't think she's exclusively a public official because she is a private individual that serves on this board that then goes and serves on these things. But at the same time, when it reaches a public official level, we should do those through collaborative processes and actually establish those requirements at the top levels.
So, I'm not talking policy.
Okay.
I'm talking, does strict scrutiny apply or?
Strict scrutiny applies even at all levels, even at the top level. What the determination is under that strict scrutiny varies on a case-by-case basis. And I don't think—
You said earlier, if it's a public official, it's okay.
What I said is top levels of public officials. The case by the U.S. Supreme Court was challenging mandatory retirement ages for judges in a state. And what the Supreme Court said in that case was they don't even fall under the age discrimination provisions because they are top level officials, top executive level officials at the policymaking level. So they actually specifically excluded them on that basis. However, the further down you go into the down the list of public officials, the more likely those restrictions are to violate that strict scrutiny. And here, I'm not even sure they pass the rational basis test, but going down, they don't necessarily the further you go down, they will, it's harder and harder to pass that strict scrutiny. It's at that top level that it was allowed to pass the strict scrutiny, and only at that top level in that case.
So what about the Board of Governors? Are they public officials? Because they also have duties.
And I think that is a great question that's been left open actually under the North Carolina Board of Dental Examiners cases, because in that case, the state asserted that they were public officials, and what the Supreme Court decided is these are all private actors serving under a quasi-governmental thing, and they're subject to a 1983 action and Sherman Act for antitrust violations. So they were subject to that because of the monopolistic and protectionist outcomes of having it regulated by members of the same practice enterprise.
Thank you.
All right, you have a minute 40 left, Mr. Paloon, on reply. Mr. Camacho?
Good morning, Your Honors. And may it please the court, Vince Camacho on behalf of the Guam Board of Governors for the Guam Bar Association. In this case, the petitioners have filed a petition against specific amendments to the GBA bylaws proposed by the Board of Governors. These amendments were voted on by an overwhelming majority of the GBA membership who cast their votes and have been duly certified with this court.
Can the GBA membership vote on bylaws that are not consistent with our rules?
According to
Approve them?
rule, sorry, Your Honor, go ahead.
No,
Yes, according to Rule 7 of the GBA rules, which governs the elections, the Board of Governors may not adopt bylaws that are inconsistent with the GBA rules. That is correct.
so how is this adoption of this temporary membership category, which appears to create a third class of membership, consistent with the membership Rule 2, which states that we only have two classes of members, active and inactive?
And I think that goes back to the history that the court was speaking of earlier, that this is the very first time since the adoption of the GBA rules and with the adoption of the Guam, the bylaws, in which none of these have been updated. If you recall, the Supreme Court, this very body, implemented the Guam rules. Sorry, it's a very long acronym. The rules governing admission and rules of discipline of attorneys, and you adopted this in 2006. So this Guam Bar Rule 2 was actually in place before the court adopted the Guam rules governing admission to practice of law.
I mean, we referred to them in those Guam rules governing admission to the practice of law as temporary active members, but we never went back and created a separate category of membership.
That's correct.
Right. And also there was a provision in the law, 7 GCA 9A114, that says these temporary active members would be, or government attorneys would be active members of the Guam Bar Association.
That is correct too, Your Honor. However, if we read the comments, right, so prior to the Supreme Court of Guam being impaneled in 1996 and ultimately the rules being in place, Guam law governed the admission and the admissions of attorneys and the practice of law in Guam. And that is found at 7 GCA Chapter 9. Chapter 9 Appendix A was actually the section that upon the promulgation of the rules of this court in 2006 would override certain sections of 7 GCA Chapter 9 Appendix A. When we take a look at what the provision in 7 GCA 7114A, that's the provision involving temporary actives. And in that case, they weren't called temporary actives, they were called government attorneys. And so when this body created the Guam rules, I'm going to call it, GRGAPL in 2006, that's where this court took those rules out of 7 GCA 7114A and actually embodied them into the new rule.
But in the rules governing admission to the practice of law, we don't set forth what the rights and are for each of those categories of members, right?
That's correct, Your Honor. That is left up to the Board of Governors for the Guam Bar Association, who has the authority to govern the Guam Bar.
What's the rationale for saying that these temporary active members who are entrusted with advising clients on most and perhaps even life-changing decisions, but aren't able to participate in the running of the organization? What's the rationale for that?
Well, there's several, Your Honor. I mean, one is local representation. By requiring board members to be residents of the area served by the Bar Association.
No, I'm putting separate from
the residents.
From the resident, because these people have moved here, they're residing here, they're residents of Guam, although they may not have passed the Guam Bar exam, they're government attorneys. admitted to the practice of law by the Supreme Court. So apart from the residency and the durational requirements, what is the rationale for saying that these lawyers who were going to charge bar dues to, who we entrust with the practice of law and can advise clients on matters of utmost importance to them, yet they can't participate in the organizational activities of the Guam Bar other than to constitute a quorum?
Well, they're not there just to constitute a quorum, Your Honor. They're also there. They can serve on those committees. They can serve, they can obtain any other membership benefits that all other active members is. But what the
They
Guam
can't
Bar,
vote according to the amended bylaws, right?
that is correct. There's two things that temporary actives cannot do under the new bylaws. And one is vote, and the other is to run for office. Other than that, that coincides with other jurisdictions that limit the practice of law in Guam or in their jurisdictions because an individual has not taken the Guam.
Actually, Hawaii allows their government attorneys to fully participate in the bar activities, including voting.
Yes, and I'm not saying all bar associations do this, but there are other bar associations that limit the power or the benefits that a non-barred resident receives.
Admitted to the practice of law?
Admitted to the practice of law for limited purposes, right? Also limits.
What
their
other
ability-
jurisdictions have government attorney admissions?
Well, I think, like, for instance, I think we cited some in our briefs. For example, Washington, DC allows government attorneys or other attorneys to practice for a limited basis, and they're not even part of the bar. They're not even entitled to join the bar. If they're not even entitled to join the bar, they're not entitled to any of the benefits. We're not excluding temporary active members from any other benefits, or these bylaws do not exclude the temporary actives from any other benefits other than ensuring that the Guam Bar Association, under the Guam Bar rules and under the bylaws, are governed by individuals that have full-fledged and the authority granted by this court to practice in Guam.
Mr. Camacho,
Yes.
I want to go back to the Chief Justice's original question because I don't think you've answered it, at least not in my mind. So my issue is not whether it's wise that the Board of Governors has decided to create this division, but it goes back to its powers, because I'm myself speaking personally for myself. I don't think that it's my role to interfere with the governance so long as it acts within its powers, and whether or not the policy decision that it makes is a good decision, that's for the membership, in my mind, to weigh in and decide. But in going back to the original question, where can you point to? And you've kind of given us the history, which just comes down to that these GBA rules, as I would refer to them, are the foundational document. They're the constitutional-like document that governs the powers of the board. And so I'm having issues pointing to a provision in the rules that allow for the creation of this third category. If you follow the interpretation of the petitioners, that their Rule 7, Section 1 creates only two classes, active and inactive. And so where is the power derived that the Board of Governors can create this third category?
Well, I think Your Honor expressed it earlier. This is not a creation of a third category because they're still actively practicing in Guam. However, they are limited in terms of where they can practice and who they can practice for. And that's the gist of the distinction between an active and a temporary inactive. The board feels it's very important, especially in light of the fact that at the beginning, the courts and this may be before this court, it could have been through the statute, prior to the Supreme Court coming in. Temporary actives were limited to 2 years. Now we're looking at the ability for the temporary actives to work for 5 years, an additional 3-year extension. As we stated in our brief, the extension is not a problem. The problem is when you have other specific areas of the statute that don't define specifically active or temporary inactive. For instance, if a temporary inactive is allowed to practice on Guam for 8 years, if you go to the appointment of judicial judges, the requirement is 7 years. So does this mean someone who's not barred on Guam, who has met the 7-year residential and durational requirement, is allowed to be appointed on Guam? So that's a question that the board raised. And so in trying to answer that question through the board's governance, the board said, all we're doing is we're saying we need to distinguish this because there could be other sections of the statute within Guam law that says active members, not considering that they may not be fully vested with the rights and privileges of all other individuals on Guam who pass the Guam bar. And that's all that the board was trying to do here is there's individuals who have full-fledged rights to practice bar. Under the GRGAPL, there is no comity, right? So this body has the inherent power to admit individuals, not the Guam bar. It's this body. This body has recognized the need for individuals to be able to come in and help the government and has allowed these individuals to come in on a limited basis. And over the years, yes, the time has changed, but as this time starts to get extended, now we start to question, are these guys really active? What, I didn't even know certain people were were temporary actives. The only way I knew that is there's an asterisk by their name. But does the public deserve to know who really is on Guam, a limited temporary active versus an active? And I think that's the clarification the board was seeking.
But yeah, while the consequences of creating the categories, I don't necessarily see that as an issue that is before us. I think what is the issue before us is whether or not the Board of Governors has the authority to create this third category, at least as to the Amendment 1.
Correct.
And so what consequences that may have in terms of how it's interpreted by the legislature and in reference to holding a judicial office, that to me doesn't come back to whether or not Rule 1 authorizes Rule 7, which creates the two categories, whether or not that is violated as a result of creating this third category. I think that's the question that is before this court, at least as far as the First Amendment. Now, when you go beyond that and in reference to whether it really makes sense and whether we agree or not agree that creating this division, when the Bar Association, in my mind, now just stepping out a little here, the purpose is to try and encourage and support members so that especially when the community is facing with a shortage of lawyers to take on the various representation roles that is needed, whether or not it makes a good policy sense. That to me is for the members to decide. And the composition of the Guam Bar Association. It just doesn't make much sense to me in reference to if you're going to get into the purpose of why this association exists in reference to helping the court provide legal representation in our community, that there would be this division and limitation that is being placed.
I just want to clarify one thing, Your Honor. So when you're referring to the rule, you're referring to GBA Rule 2, right? Which is the one that says there shall be two.
Okay, so it is the rule. Is it the rule 2? Yeah, I don't.
Rule 2 of the GBA rules. I just want to confirm that because Rule 7 of the rule
Is-
refers to the elections.
Amendment, okay.
Yeah, but
Yes,
rule
rule
7 was bylaws can't be inconsistent with the rules.
Right. Correct.
So, I guess the basic question is, what rule can you point to that will authorize the Board of Governors to create this third category? Now, you've said that, which is something I had raised earlier, that temporary active is active. But when you take away all of the other entitlements, other than that it will, this membership can count towards a quorum, that's not really the same.
Right. There's nothing in the GBA rule that governs other than what the purpose for the GBA is and what the GBA does in helping govern the GBA. So what the GBA is doing here is invoking its authority to manage the GBA. It's not attempting to take away any benefits of anyone that this court allows to.
But it does
practice
that
in
when
the
it
law.
takes away the voting rights of the new class of membership that is being created.
Right,
And,
and
and the ability to hold office.
correct. And that's not uncommon amongst any other organizations, special limited organizations, individuals.
But the Guam Bar isn't just an organization of friends. It governs the practice of law.
Yes, it does, Your Honor.
So is the Board of Governors and the president in a public officials, or are they private?
They are technically private. However, when they are governing or working with you in the Supreme Court with regards to the admissions, when they are working in their duties as bar examiners or any other assistance that the Guam Bar does. I mean, keep in mind, the Guam Bar cannot make decisions that affect the public. They cannot make decisions that affect anyone outside of the membership in which this court says can be part of the profession practicing law in Guam. So what the Guam Bar is doing here is they're not changing anything. I mean, yes, they're not allowed to vote and they're not allowed to participate in the board, but they are allowed to participate in all the committees. They are allowed to participate in all the CLEs. They are always invited to everything the Guam Bar has. And hopefully, if this court grants it and there is an attorney assistance program, they will avail of that as well. But when we're talking about governing of a profession of law, isn't it consistent and reasonable that the Board of Governors be individuals that have full faith and privileges to practice in the jurisdiction?
Well,
I don't
don't
think
they
that's
have that by
unreasonable.
virtue of their admission to the practice of law here? At least for the time that they're admitted to practice law as government attorneys?
Yes,
They have all the privileges of the ability to practice law.
correct. And I think the distinction is just for the Bar Association is to ensure that there is still this delineation for purposes of making sure that the term active in and of itself does not lend itself to misinterpretation with other statutes, such as the judicial statute.
If I could go to another subject,
Yes, Your Honor.
the petitioners have asked that this court set aside only 5 of the amendments. But they've also argued that the procedure for the election was improper have they waived that argument when they say, okay, 26 are fine, let them go? It seems to me they can't argue that there were significant procedural defects and they should be set aside and then say 26 are okay.
That's correct, Your Honor, and that's why, we asked the court to lift the stay on the 26 that have passed and have not been challenged. Because again, those were overwhelmingly passed by those that voted for those. And there was no
But if there was a problem with conducting the election, for example, if hypothetically we say that bylaw proposals only had to be submitted by 25 members of the Guam Bar and not by the board, then doesn't that throw into question all of the amendments?
It does, but that argument, Your Honor, is very faulty, because if we really look at Rule 7 very clearly, the first two sentences of Rule 7 give the board the authority to amend the bylaws as long as they hold an election. The alternative, if the board doesn't.
Where's the specific language in Rule 7 that says the board can amend the bylaws?
It says the initial bylaws of the Guam Bar Association shall be submitted to the Guam Bar Association and approved and adopted by order of this court to take effect upon the effective date of these rules and bylaws. Then it says the next operative line, bylaws not inconsistent with these rules may be adopted, amended, or repealed by the active members in good standing voting by ballot or a regular meeting or special meeting of the members. There shall be at least 10 days notice. So these are just proposals submitted by the board.
Right. It doesn't say anything about the board submitting proposals, right? I mean,
it says the board can adopt. That's not inconsistent with these rules, as long as.
It doesn't say that, does it? There's no language of the board may adopt.
Well, the board didn't adopt anything. The board
It says bylaws not inconsistent may be adopted.
Correct. Amended.
That's not the board adopting those bylaws. It's the active members in good standing. But then further below, it does say proposals may be made by 25 members in good standing.
Yes, and that's the alternative, right? So if the board doesn't propose these amendments and hold an election, then 25 members may.
But there's not explicit authority for the board to propose amendments, as there is an explicit disapproval of board members submitting proposals, right? It doesn't, the bylaws don't say board members can or cannot. It's silent on that issue.
Right. Yes, it is.
I'm a little, I was trying to understand the finality, the recount language that was proposed. When I looked at the amendments, the first provisions, and I can understand and in fact that language was already there about results determined by the recount committee being final and not subject to further challenge. But it was this other line that says all other elections other than the results for election to the board will be final and not subject to further challenge. And you're saying, I thought I was understanding that you just wanted one time for a recount and not have it gone ad infinitum. But does this language suggest that if there is an amendment and it's a very close election that there can't be a recount?
Oh, not at all, Your Honor. As a matter of fact, I believe the amendment specifically says that a challenge to the recount does not apply to the election of the Board of Governors.
So the board, yeah, I understand that, but I'm talking about if there is a board amendment that's being proposed and it's a very close election, let's say it's by a one vote.
Correct.
So under that scenario, there cannot be a recount?
Oh, no, not at all. It's just saying that if there is a recount, because the section here just only deals with recounts, right? So if there's a close election and someone applies to the board for a recount, the recount process will happen.
Well, the recount process now seems to be only limited to when a candidate is dissatisfied with the result of his election. So it allows a candidate for office, presumably, to then have a recount. And then, so that language I don't think changed, other than to get rid of examining the envelopes, the paper ballots, and who the results got reported to. And then the recount committee vote was always final, even under the old rules.
Correct.
It's this new language that's in there. And you're excluding from that the election of the Board of Governors. So it seems to suggest that there's where's the recount process for allowed, for example, an amendment or another election or another issue that might come before, other than election of the officers?
Well, I think that's what this language is trying to clarify, because this entire section, which is Article 9, deals only with the election of the board. And I think what this last language is that says all other elections other than the results of the election to the Board of Governors shall be final and not subject to further challenge. And because this is located in the recount, I'm assuming, and I don't know for a fact, that any other election that requires a recount, whether it's, well, if it's for the amendment like Your Honor is asking for, that recount will be finalized after the recount. There's no further ability to do that. But if that's something that's unclear, that's not what the petitioners are arguing. Right?
What about going back to this constitutional challenge, the right to travel alleged violation? The respondents in this case state that the purpose or a basis for the residential and durational requirements is the efficient administration of the GBA, but yet fail to articulate how these residential and durational requirements achieve that. So can you expound on that, and how is it that it contributes to the efficient administration of the efficient administration of the GBA? That was the rational, assuming the rational basis applies, and you're needing to satisfy the rational basis scrutiny. How specifically do these durational and residential requirements achieve that?
I guess you're asking how they pass rational basis.
Well, I'm trying to I'm trying to understand a more specific articulation, just other than it goes, it supports the efficient administration of the GBA, or it achieves an efficient administration of the Guam Bar Association. How does it do that? Is my question.
Thank you, Your Honor, for that question. This is something I wanted to head into earlier. First of all, it provides local representation, right? By requiring board members to be residents of the area served by the bar, the board ensures that it has representation from individuals who are familiar with the local legal landscape, understand specific needs of the community, and can effectively advocate for local issues. 2, there's a community connection between the board members who live in the community they serve, may have longer, stronger connections with the local legal community, professionals, judges, and community organization. This can facilitate collaboration, networking, and partnerships that benefit the Bar Association as well as its members. 3, commitment to the jurisdiction. Requiring residency demonstrates a commitment to the jurisdictions and its legal community. Board members who are invested in the area are more likely to prioritize the interests of local attorneys and work towards the improvement of the legal profession within Guam. 3, accessibility, and probably one of the most important issues is because we are thousands of miles away from any nearest bar other than Saipan. Residency requirements can embrace and enhance accessibility to board positions for the local attorneys who are actively practicing the law within the jurisdiction. This ensures that the board reflects the diversity of the local legal community and includes perspectives from practitioners who are directly impacted by the association's discussions. 5, understanding of local issues. The board members who reside in the jurisdiction are more likely to be attuned to the unique challenges and opportunities, such as bringing our people home to practice law in Guam and the legal developments affecting the local community. We all know we're all part of the legal community. We have struggles. 1, to bring new practicing attorneys, at least for the private bar. 2, the indigent representation issue. And so those are issues that individuals who are barred on Guam, who are private practice practitioners, can help the bar and the board, the court, come together to help solve these problems. Individuals who are not practicing in the private sector may not, I'm not saying they don't, but they may not understand what it is like to run a business, to practice in the practice of law, and at the same time survive. There's a lot of issues that surround those in the private bar that may not be of concern to those. The last I checked, there are only 12 temporary admittees. So I'm not sure how this would really affect them being able to vote when the rest of the bar has full-fledged authority provided by this court to administer the practice of law. So in addition to understanding the local issues, there's accountability. Residency requirements may enhance the accountability by ensuring that the board members are directly accountable to the local legal community they represent. This accountability can help factor and promote transparency in the governance of the Bar Association. So those are the reasons, Your Honor, why the Guam Bar believes, the residency requirement is important. And I think those are rationally related to the amendments that were passed by the majority of those that attended the vote and voted.
So are you saying temporary active members are not residents?
No, we're definitely not saying they're not residents because they have to pay taxes here, but what we're saying is that.
So wouldn't they qualify?
To
be, if they're a resident, they qualify for board membership, right?
Well, that's what they're challenging, right? So they're saying being a resident of Guam prohibits their right to travel, which we don't foresee. I mean, many of us are barred in other jurisdictions and make Guam our home. They decided to make Guam their home, but they're not permitted to practice in all areas of law in Guam other than with the government. And rightfully so, right? I think that's a really good opportunity for us to bring people to Guam.
But there are government attorneys who could practice and engage in private practice. There are many of those, right? That are eligible to, because you made a distinction between those in private practice and those in government attorneys earlier.
Yeah, I'm sorry if the court misconstrued. What I meant was the major distinction is passing the Guam Bar.
Yeah, it's just it's the exam, taking the test.
Correct.
I think your time is up, Mr. Camacho.
If I can just close with one final statement, Your Honor. Take less than 30 seconds.
That's 30 seconds.
Sorry, Your Honor, 30 more. So, Your Honors, thank you very much for this opportunity to represent the Guam Bar Association Board of Governors on their behalf. The Guam Board of Governors respectfully requests that this court deny the petition seeking to overturn amendments 1, 3, 6, 7, and 12, and to immediately lift the stay on the 26 amendments not challenged by the petitioners. If the court agrees with the Board of Governors that they have the authority to make these changes for 1, 3, 6, 7, and 12, we ask that the court deny the petition. Thank you very much, Your Honors.
Thank you. Mr. Pallone, you had 1 and 45. I'll give you 3 minutes. The extra time.
Okay, thank you. I'm going to start by answering a couple specific questions. Justice Merriman asked a question about the waiver related to the challenges. I think this is 2 parts. When it comes to the substantive challenge, we have challenged the proposals 1, 3, 6, 7, and 12. And when it comes to the procedural things, that does apply to all of them. They were ordered in the brief as the substantive challenges first and the procedural ones second, but that's merely to highlight the real underpinning problems with these proposals, not to waive a challenge to the entirety of the election on procedural grounds. As to the finality language, the petitioners also are unsure of what it means, and that's part of the problem. If we are going to adopt that rule, we need to be specific as to what it is and how it actually works. So the challenged proposals here are, in essence, an affront to this court's organic act authority to regulate the practice of law in Guam. The proposals both violate the GBA rules and are unwise. Either of those is a sufficient reason to set them aside. These proposals create a third category of inferior membership. There is no other jurisdiction that recognizes an inferior category of membership like this and tells these members that they cannot vote. The Board of Governors, which, going back to a question earlier, for purposes of regulating the profession, like the medical examiners, Board of Medical Examiners, the Board of Dental Examiners, this accountancy board, would be public officials, admit that temporary active members will not have the right to vote or hold office. This is an unprecedented change and marginalization. The GBA is not meant to serve only the private bar. It is meant for all attorneys. The local representation, the community connection, the commitment to residency, and the accessibility can be certainly fulfilled by people that have either in whole or in part spent their time here in Guam as temporary members. None of that is a justification for taking away their right to vote. The board instead seeks to bring up issues that are not even within GBA's authority to regulate, such as judicial qualifications, which belong to the legislature, and in making categories of membership that belongs to this court. And if I come across as a little bit indignant today, I think that is a little bit because I am. Even a vote of every other active member of the Guam Bar Association should not justify taking away a right to vote and participate in a fundamental organization that governs the very profession in which we participate. We are licensed attorneys and we deserve to be treated the same as every other licensed attorney. No more, no less. Thank you.
Thank you, Mr. Pallone. Thank you for the arguments, counsels. The court will take the matter under advisement and will now stand adjourned.
All right.